Hi, I'm David, staff attorney at Neighbors Link Community Law Practice, talking to you today about why your green card is only valid for 2 years when your friend's is good for 10. You and your spouse had an interview with USCIS last month, and your green card just came in. You are relieved, but confused as to why USCIS only gave you 2 years when your friend has 10 years. Do you need to fix this? You don't remember your lawyer telling you that there was anything more to do? Now, if you were married for less than 2 years at the time that USCIS interviewed and approved, that means you received only a conditional permanent residence instead of a lawful permanent residence. The card will say CR and will have an expiration date of 2 years from the date of issuance. As a conditional resident, you have the basic rights of a lawful permanent resident, but you do not yet have the full resident status. You can work, travel, and petition for other relatives while in conditional status. Importantly, unlike lawful permanent residence, conditional residency expires if you do not apply to remove those conditions. Okay, so now let's use an example. Meet Jenny, a wistful Italian university student who is visiting the United States and on a tourist visa when she meets Jess, a United States citizen. They fall in love immediately and marry. Jess files a petition for his new love. USCIS schedules an interview 9 months later and Jenny receives her conditional residence with CR6 on the card, good for 2 years. Jenny now has all the privileges of a lawful permanent resident, but must remember that she is required to file an application to remove the conditions on her residence. So, when does Jenny file the application? Jenny must file Form I-751 within the 90 days window prior to the end of the 2-year period on her card. So what happens if Jenny forgets? If USCIS does not receive the I-751 before the card expires, Jennifer's residence status will be automatically terminated and Jenny will be put into removal proceedings to explain the situation to an immigration judge. Now, there are a few exceptions to this rule, so Jenny must remember to file her application timely. It is really important to remember that a conditional resident has a responsibility of filing the I-751 whether or not their lawyer or USCIS reminds them. It is their responsibility. Jenny is still happily married to Jess, remembers to file the I-751. They file the application jointly, they both sign it, they both submit it to USCIS along with copies of bona fides, updated versions of the same documents that were filed with the initial petition. That shows that Jenny and Jess are still living together. Now, filing the I-751 will automatically extend Jenny's conditional residence. As noted on the receipt from USCIS, sometimes USCIS will adjudicate the I-751 application without an interview, but other times the couple is required to attend another interview. Okay, so let's change the scenario up a little bit. Jenny and Jess realize that they married very quickly and aren't as happy as they hoped. Can Jenny remove the conditions on her residence if she and Jess are no longer married? There are waivers available to the joint filing requirement, but they are very specific. Jenny can request a waiver of the joint filing requirement if she and Jess are granted a final divorce before the filing deadline. She will still have to prove that the marriage was entered into in good faith before being terminated. This waiver is only available if the divorce is final. If Jenny and Jess have a pending divorce or have separated, Jenny cannot request this waiver. Jenny can also request a waiver if she has suffered extreme cruelty or if she can prove that a qualified relative will suffer extreme hardship if she is deported. As always, immigration law is complicated and depends on many factors. It is very important that you consult with an immigration lawyer before making any decisions. And if the lawyer you speak to isn't clear or doesn't respond to your question, find a lawyer.